Thank you for coming by. It's the American Project. Please be sure to like the video and subscribe if you haven't done so already. Consider my second channel. The link is at the top of the screen. I'll have one at the end as well. You can jump right to it if you'd like to. Well, the federal judge, Eileen M. Cannon, ruled that Trump could not escape prosecution by arguing that he had converted the highly sensitive records he took from the White House into his personal property under a law known as the Presidential Records Act. She's been under a lot of pressure by Jack Smith to move it along, the special counsel. He was getting a little bit antsy about it. So the judge made a ruling, 3-page order. Judge Cannon said that the statute, which was put in place after the Watergate scandal to ensure that most records from a president's time in office remained in the possession of the government, does not provide a pretrial basis to dismiss the case. The decision was a victory of sorts for the special counsel Jack Smith, who has persistently argued that the Presidential Records Act should have nothing to do with the criminal prosecution of a former president accused of removing national security documents from the White House and then obstructing efforts to retrieve them. Smith had laid out his own solution to the problem he believed that Cannon had created. He said the judge should issue a ruling on one of Trump's most brazen defenses in the case, and she should do so quickly, affording prosecutors a chance to appeal if she decides against them. He wants this done before the election, so he's pushing her right along, but she's just moving at a normal pace rather than pushing at high speed. So Cannon gave Smith a bit of what he asked for, but not everything. She issued the ruling just like he'd requested, rejecting Trump's attempt to escape prosecution by arguing he had converted the highly sensitive records. The dispute, while specific to the classified documents prosecution, points to the broader ways in which Trump's lawyers have managed to gum up his criminal cases, including those in Washington and Georgia, based on similar charges of plotting to subvert the 2020 election. His legal team has repeatedly thrown sand into the gears of the proceedings, grinding them into all but a halt with endless waves of motions, many of them bordering on frivolous, according to some. Trump's team privately has been open about the strategy of delay, and it has been so successful, in fact, that at this point it is possible that only one of Trump's 4 trials will go in front of a jury before voters go to the polls. That would be his trial in Manhattan on charges of covering up a scandal surrounding his 2016 presidential campaign. That is set to start on the 15th of April. From the start, Trump's attempt to use a law known as Presidential Records Act to lay personal claim to highly classified papers was a stretch. The assertion is dubious on its face, given that the statute was put in place after the Watergate scandal, not so that presidents could unilaterally designate government documents as their own personal property, but for the opposite reason, to ensure that most did indeed remain. Even Cannon herself balked at the idea last month at a hearing in Florida, telling Trump's lawyers that their interpretation would effectively gut the Presidential Records Act. But then, within days of the hearing, she suddenly seemed to reverse herself, ordering the defense and prosecution to send her proposed jury instructions that suggested she was still open to embracing the defense. The order was unusual for a number of reasons, not least because jury instructions are typically hashed out on the eve of trial, and Cannon hasn't even set a trial date yet, despite the fact that both sides have said they could be ready for one by summer. But it was even stranger because by appearing to remain open to Trump's position on the Presidential Records Act, Cannon seemed to be willing to consider nudging any eventual jurors towards finding him not guilty. Her order left open another possibility that she herself might acquit the former president near the end of the trial by summarily declaring that the government had failed to prove its case. Smith was hoping to avoid either of those pitfalls. He responded to the order by telling Cannon that the Presidential Records Act had absolutely no relevance to the case, that the defense Trump had based on it was pure fiction created out of whole cloth and untethered to any facts. Smith also said that Cannon's own plan to receive jury instructions based on the act was completely wrong-headed and rested on a fundamentally flawed legal premise. What he wanted was for Cannon to decide the validity of the Presidential Records Act's defense in a different way, by rejecting Trump's motion to dismiss the case based on the same argument. Today, she did just that. But while her order rejected Trump's attempts to kill the case with the Presidential Records Act defense, it suggested that the conversation about how the act might show up during the trial itself would continue. Cannon, in fact, chided Smith for wanting to end the discussion about jury instructions prior to the presentation of trial defenses and evidence, calling the request unprecedented and unjust. She also defended her decision to ask both sides for their dueling takes on jury instructions. Her request, she wrote, should be interpreted as a genuine attempt in the context of the upcoming trial to better understand the parties, competing positions, and the questions to be submitted to the jury in this complex case of first impression. In other words, it may not be the last we hear about the Presidential Records Act. And there you have it. Thanks for coming by. Please be sure to like the video and subscribe. I really appreciate it. And have a great day. God bless.